for filing and protecting liens in Florida. Just before we get into that, just what is a lien? It's really basic, but to step back a minute, what is a mechanics lien or a construction lien in Florida? It operates much like a mortgage would. It attaches to the property and it becomes an encumbrance against the property that must be dealt with, you know, along the lines if the property is to be sold. So you can think of it much like a mortgage, but it's an encumbrance against the property that's related to the labor and materials that are provided to improve that real estate. So if you are a subcontractor or a material supplier, you are working with either an owner direct, you're contracted with a general contractor, or you're contracted with a subcontractor of the general, or you possibly could even be as low as contracting with a subcontractor of a subcontractor. Those levels in that contract here do have lien rights under the Florida statutes. But where you fall in that chain, whether you're direct with owner or direct with a general, will determine what steps under the statutes are required to be taken in order to maintain and keep your lien rights and assert your lien rights and eventually perfect them if you need to, essentially file a lien. But just like in most states, in every state, really, mechanics lien rights, construction lien rights are statutory and they're governed by statutes that are enacted, and those statutes must be followed strictly. If you don't follow those statutes strictly, you can lose your lien rights. So let's talk about some of these situations. Like if you are contracted with an owner, there are certain things you must do, and what that does is it governs whether you have to provide any sort of types of notices. So a preliminary notice, that's one notice that most states have under certain circumstances. You must provide a preliminary notice that you may assert your lien rights or file a lien. You don't always have to do that, and that will be determined whether you have to or don't have to by where you fall in that contract chain. Are you direct with an owner? Are you direct with a subcontractor to the general? Or are you direct with the general? Where is your contract? In Florida, you do have to provide this preliminary notice, which again is by statute, a specific notice with specific language and looks a certain way based upon the statute. You have to provide that under certain circumstances. You don't have to provide it if you have a contract direct with the owner. That's a generalization, but in general, you do not have to provide or serve a preliminary notice that you may file a lien on a project. You do not have to serve that on an owner if you have a contract direct with the owner. There is a statutory exclusion, however, that says unless you are actually serving as a contractor under the contract direct with an owner that involves a residential situation of 4 or fewer dwellings, then you are required to provide a preliminary notice, and that specific by statute must be included in your contract. And the statutes set out what that should look like, what it should say, and you got to put that on the first page of your contract if you're dealing direct with an owner. And actually, technically, the statute requires that in contracts of over $2,500. So if you're direct with the owner, but it's a residential project of less than 4 or less residential dwellings, there is a preliminary notice requirement, but it is to be included in the written contract. A situation which is more common for many of the clients that we work with is that they are a material supplier or a subcontractor to a general or to another subcontractor. In those circumstances, when you're not direct with the owner, a preliminary notice is required to be served on the owner and all parties in Florida. Now, service is defined specifically by statute again. What does that mean? Well, we typically recommend certified mail. It's simple. Everybody understands what it is. It is included in the statute that service of a preliminary notice may be done by certified mail, and that must be done within a certain deadline. So when you're determining your project, you figure out that you are a subcontractor to a general or a sub to a sub. You need to note that I have to do a preliminary notice, and I have to get that done within 45 days after my first date or within my first date of labor and material furnishing. We encourage our clients to do that as early as possible, and you can do that even before your first date, but do it as soon as possible so you don't have any question as to whether you've done it within the 45 days of your first date of furnishing labor and materials. That is by statute. If you miss that deadline, you will lose your lien rights. So what I want to focus on that preliminary notice is, again, that's a statutory notice. It's required when you're in that contract chain below the general, that you must do that within 45 days, and you must serve that by statute by certified mail. There are other ways, registered personal service, but certified mail will cover you. Now, I said that under Florida law, the 45-day preliminary notice must be served on the owner and all parties within 45 days. However, there's also, and this usually is generated through a case law from the interpretation or specific statutes or the interpretation of the statute, there are often provided rules for what's called the mailbox rule, which gives time for mailing. So when you serve somebody by certified mail, they may not get that in 5 days. So the statutes and case law have set that situation up and said that we will allow for the mailbox rule to apply if you provide your notice and mail your notice by the 40th day of your first date. So if you're sending that notice out before the 40th day, that's why we again encourage it to do it early, then the mailbox rule applies. So if that gets stuck in the mail or goes out and they actually receive it after the 45 days, it's okay because you mailed it before the 40th day. Now, if you're going to send your notice out between the 41st to 45th day, you got to make sure they get it. So there may be a situation where you don't do a certified mail. You may do personal service if balance justifies it. You may do FedEx, because the statutes will provide for some third-party verified delivery, but they have to have you have to verify that they have delivered that within those 45 days. If again you fail when you need to serve timely a preliminary notice, you will lose your lien rights. And the statutes provide exactly what that notice should look like. Florida is a little different than many states in that they have another piece of the puzzle, which is a requirement that the private owner prepare and file a notice of commencement. There are a number of states that have notices of commencement, and Florida is one. A notice of commencement is a statutory form notice that is filed with the court. That's supposed to be filed before the work starts on the project, and it lays out who everybody is. It includes information and name and address of owners, general contractors, any sort of lenders. And what that does is that it really helps out lien claimants for determining where they need to be sending preliminary notices and who's involved in a job. Because you can't always tell right away from maybe sales who the owner really is. You might know where the project is, but you don't really know the owner. But if you go get that notice of commencement, which is filed at the courthouse and is also supposed to be posted to the project site, that will give you the information of who the owner is, and they can even have an owner's designee, which is the person that you're supposed to provide notices to. That makes it really clear. So when you get a copy of the notice of commencement, what needs to be made sure is that that preliminary notice is going to the parties that are contained in that notice of commencement. One question that could pop up is what happens if you go and you can't find or there isn't a notice of commencement. They're supposed to do that before the project starts, but what if they don't? Well, then it doesn't exist. The statutes in Florida specifically provide that you can rely on the information that you can pull from a building permit. So you then get the building permit and use the information from the building permit to determine who you should be serving preliminary notices on. So the notice of commencement is important because it helps you determine that your project information is correct. It helps you determine where your preliminary notice needs to be served. and then you just make sure that that gets served timely so that you do not lose the ability to file a lien later in the project if you haven't been paid. Let's assume that you have done everything you needed to do. You've obtained all of the information of the project. You understand it's a private project, so it's lienable. You are providing labor and materials to a project, and you're in the contract chain high enough that you're working with a subcontractor or a general. So you have lien rights, and you made sure you timely served your preliminary notice. Well, that's just the beginning of the job. Now you do all your work, but let's say you haven't been paid. What do you do? Well, that's the next step of securing your mechanics lien if necessary. And the important thing to consider there is the timing of that, because there are deadlines, again, by statute that require that a mechanics lien be recorded and filed by a certain date. If you miss that date, you lose your lien rights. So you may have done everything else perfectly up to this point, but then once you're done furnishing your labor and materials, if you haven't been paid, you need to record your lien, the clerk of courts of the county in which the project is located. You need to do that within 90 days after your last date of furnishing. Again, if you miss that date, you go past the 90 days of your last date, and in most case law is going to define that last date as some sort of substantial last date of furnishing. It won't be a $7 invoice. It won't be somebody going out to turn a couple screws on a screen door. It is some last substantial furnishing. You got to lock that date in when you know it, and then make sure you're tracking your deadlines such that if you haven't been paid, you make sure that the lien has been recorded within 90 days. We always will recommend never push it to the end, because you don't have a lot of time. There's another step that the statute requires in perfecting your lien, in that the owner has to be served with that claim of lien that's recorded with the court. So you have to do that, and if you aren't able to do that, you will lose your lien rights as well. So you do have to not only file it and record it, you have to serve it on the owner. So in order to do that, I say give yourself time. Don't wait until the 88th day to figure out what to do. So once you know your last date, you should be tracking that so that at 60 days, you're seriously considering whether you look to be paid or not, and how important and how much the balance is, and how important your relationship is with the general, and things like along that nature, to determine whether you better just get out there and get that lien recorded and give yourself the time to get the owner served. So 90 days is the important date. The previous number to remember, 45 days from first date, preliminary notice. 90 days after last date is your recording deadline. Well, once you've done that, you now have a lien against the property, and assuming it's timely. Hopefully, because of the preliminary notice, you would have gotten paid, and you wouldn't have had to file it. But if you didn't and you had to file, hopefully the filing and recording of that lien will encourage the payment, because the whole point here is to protect your money and get your money out of that flow in the project. But let's assume that you actually went through that process and that did not result in payment. Well, there's still another step involved. You have this lien that's been recorded, like I said, like a mortgage, an encumbrance against the property, but you have to do something with that lien or you could lose it again. There's another deadline where you may lose your lien if you're not watching that deadline. And that deadline is the deadline to foreclose the lien. So like a mortgage, you're foreclosing for failure to pay. A mechanics lien or a construction lien claim in Florida, you foreclose through an action with the court to foreclose your lien just like a mortgage, and then try to cut everybody who has come later out and get money out of the project, out of the property. The important part there is whether it's worth doing is whether there's any equity in the property. So there'll be a lot of title work and looking at the property to determine whether or not, is there a large construction lender in front of you? All of those kinds of things to determine whether you want to spend the time and money to foreclose the lien. But if you don't foreclose that lien timely, it disappears. At least the ability to enforce it disappears. So the deadline for that is 1 year after the date the lien was filed at the courthouse. Now, this is a separate date that you have to track. That's the lien filing date. Many states have their deadline to foreclose on a lien as 1 or 2 years or 6 months or whatever from the last date of furnishing. In Florida, it's 1 year after the date the lien was filed at the courthouse. As I've said before, with your preliminary notice, I said do it early. The deadline to file a lien is 90 days, but do it early. Same thing with the deadline to foreclose a lien. There's a lot involved to get that foreclosure action started and done properly. So you don't want to be at 11 and a half months going, well, I wonder if we should foreclose this lien. You want to try to make that determination. I would argue at like 9 months. At any rate, if you haven't been paid in 9 months after you filed a lien, which is already 80 plus days after you haven't been paid, it's been a long time. I think it's time to make a determination what you're going to do. If they haven't paid you in 9 months, I don't know that they'll pay you in 10. So get the mechanics lien foreclosure action started. You don't have to worry about missing a deadline, and you'll turn up that pressure to try to get payment or squeeze money out of the property itself. So that's sort of the last important deadline to keep in mind when you're looking at your construction lien in Florida. 1 year after the date the lien was filed, you must foreclose your lien. Now, there's another important step you have to be on the lookout for, and it again comes from the statutes of Florida. Florida statutes provide for an opportunity for the owner or general contractor to serve what's called a notice of contest of lien. And that notice, if they serve that properly under the terms that the statute requires, that will effectively shorten the deadline for starting the lawsuit to foreclose. What that really is an owner or a general contractor sort of often calling the bluff of a sub who's filed a lien to say, fine, you think you have a good lien, foreclose it. Instead of waiting 9, 10, 11, 12 months to find out if it will be foreclosed, they want to get it cleared. They can serve this notice of contest, and then that shortens that to 60 days after that notice is received. So if you receive a notice of contest of lien, they've now shortened your foreclosure deadline from 1 year from the filing date to 60 days from the notice being received. Now you have to make a decision within that 60-day period. If you do not do that, you will lose your mechanics lien claim once again. So that's something to be on the lookout for, and that can move things along. Owners and general contractors are not likely to do that if they think you really are going to proceed and they have a lot to lose, but it is a way of making somebody make a decision, and if they don't, it's a way of chiseling away some of the smaller liens that they expect people won't foreclose on. Something very important to watch out for. One other thing that is also contained within Florida statutes to watch out for is something that can change, is another possibility for the owner to do something to affect your lien rights and maybe make them disappear. And that's their right to demand a written statement of account. So an owner has a right to do that. And that again is statutory. It's how it's set out and what it's supposed to say. And it will be served on a lien claimant. And when that's done, then the lien claimant must provide that status of the account, which the statutes require, that it shows the nature of the furnishing and what the labor materials were furnished or are going to be furnished, along with information about how much is owed or would be owed, contract price, whatever the lien likely would be, the lien amount would be. And if for some reason the lien claimant refuses to furnish that written statement to the owner within 30 days after they make that written demand, they lose their mechanics lien rights. So it can clean things up as far as how much is at stake, but it is another method that the owner can use to try to shorten or eliminate some smaller liens or other lien claimants who might not know what they need to do. If you get a written demand or statement of account served on you, it must be done. You only have 30 days to do it. Sounds like it would be enough, but it can go fast. And so that needs to be provided, and that again is statutory as far as what you have to provide and how you have to provide it. And if you don't do it, again, you lose your lien rights. So these are all important things to be aware of so that you can protect yourself in a private project. Well, why is that important to do so? Why are we talking about mechanics liens in the first place? Well, that usually comes from a situation where your customer hasn't paid you and maybe never will be able to. They've gone out of business, they could file bankruptcy, they're not going to pay for whatever reason. Maybe they haven't been paid, but that's not the point. Maybe they have been paid and they took the money and ran with it and closed the business down. The importance of the mechanics lien is to give that other pocket, which is the project, is the real estate, as a pocket to collect the balance owed by your customer. In Florida, a construction lien is a double jeopardy lien. And a double jeopardy lien essentially means that just because an owner has paid the general, and maybe the general's even paid down some people, if you haven't been paid and you have a valid lien and you're able to enforce it, they'll have to pay again to pay off your lien, to make it go away. But again, you have to do all of the statutory steps to protect yourself so you can get that double jeopardy lien. A lien against funds there are many states that have a lien against funds. A lien against funds is more of a lien that attaches to whatever hasn't yet been paid in the project. So it's against the funds that have not yet been paid, and not just against the property for whatever you're owed, despite whether they've paid or not. So Florida construction lien is very powerful because even if the owner has paid once, they may have to pay again to get your lien to go away because you dotted all the I's and crossed the T's, served everybody timely, and have a valid lien. That money needed to get passed down, and they needed to make sure that they had gotten lien waivers. That's a little bit beyond the scope of what we're going to talk about today, but owners should be getting lien waivers before they should be making payments. And the statutes in Florida do provide for what a lien waiver or release looks like and what it should say. But essentially, it's an opportunity to get paid in exchange for signing a document that says, I'm waiving my lien rights. So you can do that anytime throughout the project. It could be partial payments too, progress payments. So you get a partial payment towards your contract in exchange for signing a lien waiver. And then the owner now has something that says you can't file the lien, and they're not subject to a potential double jeopardy lien. Otherwise, they're stuck. That hasn't been done and you have a valid lien, they may have to pay twice. So that is the concept of a double jeopardy lien, a very powerful thing. People would say it's not fair. Not any of my clients, but the fairness of having to pay twice, that's why the statutes require all these notices and make you jump through so many hoops to make sure you have a valid lien. Is look, they've been put on notice. The owner knows you're on the job and they expect to be paid, and if you're not paid, you're going to potentially file a lien. So they should know that you're already on the job. They got a preliminary notice received. So the fairness, I think it's fair, and it's a very powerful tool for subcontractors and material suppliers to have to find that extra pocket. There's one little piece of private projects which will basically help us go over public projects, and that is there is a right to a payment bond on a private project. We'll talk about public projects in a second, but even on a private non-public project, there could be a requirement that a general contractor has provided or requires a payment bond be furnished, and a payment bond is essentially an insurance contract where their surety is guaranteeing that the funds will be there if somebody isn't paid, and then you can make a claim against the bond. We'll talk about it a little more in the public arena, but a payment bond is a real powerful tool that enables you to get money from an surety as opposed to having to worry about getting it out of a project or squeezing it out of an owner. It's usually pretty good because these funds are there. The money will be there. A payment bond in a private project would be found when you're looking at the notice of commencement filed at the courthouse. So if there happens to be a payment bond on this private project, it should be attached to the notice of commencement, and you should treat that with carefully and make sure that you are not forgetting that there's a payment bond to be able to proceed against. The requirements for proceeding against a payment bond on a private project mirror and are very similar, if not almost exact, to the construction lien or mechanics lien steps. If you have a contract with an owner direct, there's not a preliminary notice requirement for making a claim against the bond. If your customer is the general or a sub or a sub-sub, the preliminary notice does need to be served, and it's served on general contractor at least. And I would say serve it on everybody, the owner, general contractor, your customer, so everybody knows you're doing it. And again, within 45 days after first date, that's the same as a construction lien. So you're protecting yourself the same way. So you don't have to remember different things, but you have to remember that you want to serve everyone. And I would serve preliminary notices on sureties even too. Just everybody that's on the bond, it's referenced in the bond, and as well as your customer. So that's a preliminary notice for a payment bond on a private project. The next step is a final bond claim notice, and that can be considered sort of similar to filing your lien. It's just called the final bond claim notice. You're not filing anything with the court, but it is making a claim against the bond. So if there is one that you find on the notice of commencement, and there is and you've done your preliminary notice as required timely, then you need to make a final bond claim notice or claim against the bond within 90 days after your last date of furnishing, which is the same as construction lien statutes. So, except for the difference is you're making a claim against the bond and trying to get the money from the surety. Again, like a lien, and asserting and enforcing and protecting your lien rights, the point of it is to get paid. So hopefully, just by making a final bond claim notice, you get your customer, you get the owner to push the money through the general to your customer and to you. And then you can just go ahead and release the bond claim. You don't have to get paid through the surety. You just want to get paid somehow. And you're making sure you don't lose your bond claim right on this private project by making your final claim within 90 days of last date. Just similarly to the construction lien statutes, there's a deadline to commence a lawsuit to enforce your payment bond claim against a surety. That lawsuit must be brought within 1 year after the last date of furnishing labor and material. Now, the point I want to point out, and this is not exactly the same as construction lien, because the construction lien statute says the last date for filing a foreclosure action is from 1 year from the date the lien was filed with the courthouse, not your last date of furnishing. But on a bond claim, there is nothing filed at the courthouse. There is no lien filed. There's a final bond claim, but it's not really filed anywhere. So the statutes require that the lawsuit be brought 1 year within the last date of furnishing rather than some sort of recorded date. So that's a date to track. Again, first date, last date, those are the important dates. And we would encourage you, if there is a bond, pursue it. Don't lose it. Similar to the construction lien, just like you'll see a bit of a theme here, and I like it, is that Florida's made it simpler a little bit because they've kept things the same. Some states will change deadline dates and requirements between bonds and liens, but in this case, they have a lot of the same things. So in bond for payment, a payment bond on a private project, a general or owner can also serve a notice to contest that will shorten the deadline for commencement of your lawsuit to enforce the bond. And again, it's 60 days after the date the notice is received. So it's just the same as a construction lien situation. If you receive this notice of contest of claim against payment bond, your deadline for filing a suit against the surety on the payment bond is reduced to 60 days from that notice. If you don't do it, you'll lose any right to pursue the payment bond claim, and any lawsuit would just get kicked out. just like with a lien situation, watch out for anything that looks like a notice to shorten deadlines. Now I'm going to switch gears only a little bit because we just talked about bonds a little. But I'm going to talk about public projects. When we start at the beginning, we talked about putting together a project information or a project sheet that contains all the project information. And one of the important pieces was to make sure you understood what type of project type you have. And that's because that affects what rights you have. Do you have lien rights? Do you have bond rights? If you are looking at the project and it is a public project, and what does that mean? A public project is simply going to be a project on public land. So it could be a courthouse. If we're talking federal projects, we're talking about a federal courthouse or some federal prison or federal land. States or counties or municipalities like cities, any land that's city land, county land, and you're doing a project with them. So schools, courthouses are the most common kinds of things. There's some, so you want to look at the project and say, is it public? What are we building here? Is this a school? Is it a public school? Where is it? Who owns the property? Well, if it's a municipality, a state, the federal government, then you're dealing with a public job. And why are there payment bonds or things like the Federal Miller Act, which we'll talk about in a second? The reason is because you cannot file or assert a lien against government property, against the government's real estate. You can't have a lien against the government's real estate. So in order to help contractors and subcontractors and material suppliers have a recourse if they haven't been paid, statutes were developed to provide for the requirement that there be payment and performance bonds on large public jobs, so that while we can't file a lien, but at least there's a bond that we can go after to find money from someplace else when the money doesn't flow down the way it should. So it's very much similar to the payment bond situation in a private project. It's a surety bond, and the requirements of the statutes are that those are obtained for both payment and performance, so they can make sure the job gets complete and make sure that everybody gets paid. So let's talk about federal projects for just a second. Federal projects, like I said, are federal courthouses. It could be military base, all of that good stuff, and that falls within the federal real estate and property. If you have an overall contract, not your contract, but the overall contract for the project is $100,000 or more, then the GC is supposed to furnish the government a payment bond as well as a performance bond. But what we care about are the payment bonds because we want to make sure you get paid. And the payment bond is for the benefit of those subcontractors and material suppliers. We're working under that GC in case the money flows from the government but doesn't flow through the GC to the subs and suppliers. The performance bond is something that guarantees that the project will get finished despite the fact that they may get rid of the GC or there may be some problems. You know, some people will be kicked off the job, whatever. There's money to be had to make sure that the performance is completed. From a perspective that we look at, which is collection of money, unpaid money, the payment bond protects people from getting paid when the money hasn't flowed all the way down. One important thing to think about, again, when we're looking at the contract tiers, is on a Federal Miller Act, which is the federal act that provides for bonds in these circumstances, does not protect subcontractors and material suppliers lower than the second tier of the contract tier. So no sub, I would call them. Whereas in Florida construction lien law, a sub has lien rights. But under the Federal Miller Act, you cannot make a claim against the bond if you're farther down the chain. So that's the importance, again, of looking in the beginning and seeing where you fall within the contract tier and whether you want to control that risk, and are you going to get paid, and if you don't, what are your options? So if you are higher up on the tier, better likelihood of being paid, better likelihood of having bonds protection. Lower, you don't. Again, these are for public projects, not private projects. And in the Federal Miller Act only governs the federal projects. No preliminary notice is required. Don't have to worry about that, but you do have a final bond claim notice of 90 days from your last date. When we say serve everybody, serve the surety, the owner, the general general contractor, and your customer. And similar to Florida, the lawsuit to enforce a bond claim is 1 year from your last date of furnishing. So that's very similar to the bond on the private project. Now, if we talk about the state projects in Florida, it's the same thing really as the payment bonds that we've discussed in a private project. You do have statutes that require prime contractors and general contractors on state and county projects in Florida to post performance and payment bonds, guaranteeing both performance and payment. Those bond rights exist, and you're able to pursue that bond just like you would if you found a bond on a private project. There is no preliminary notice requirement if you're direct with the GC on a public job. But if you're not direct, then you have to do a preliminary notice within 45 days, similar to the lien statutes, and that should be served on the owner, GC, and surety. And again, think about the mailbox rule and make sure you do that at 40 days or earlier, because you'll lose your bond rights if you don't do that earlier. Now, I did mention at the very beginning, material supplier to material supplier, you don't have any bond rights if you're selling to you're a material supplier and you're selling to another material supplier who's providing to a sub. The other requirements, again, like the construction lien statutes, the final bond claim notice is not required if you're direct with the GC. It's sort of like you're direct with an owner, but I would still do it because it's another opportunity to demand to be paid, and you're making a claim against the bond. You're sort of letting them know. But it is required if you're with the sub, and that requirement is 90 days from your last date of furnishing, just like with the construction lien statutes. And then finally, the lawsuit to enforce a payment bond under a public job, the lawsuit against the surety to enforce that is again 1 year from your last date of furnishing. And it'll sound like a broken record, but the statutes for public jobs in Florida provide for that opportunity for a GC to shorten the deadline to 60 days with another notice saying to get it shortened, so to force you to decide what to do. So I've kind of whistled through all of the construction lien requirements and deadlines in Florida, and the public payment bonds under federal and state. Wanted to leave some time and try to get through everything so we'd have time for some questions. And I'm sure I went fast enough that not everybody knows everything yet. But I'm open to whatever questions, and whatever we can answer now, we'll do. And anything we can answer later, we'll try to help you out with as well.
Okay, I truly appreciate you taking the time to present what surrounds getting paid in Florida, especially in the construction industry. I do want everyone to know that this is an opportunity for you to ask questions. It is simple as clicking on your icon, your name, and then typing in whatever questions that you have. So our first question is for Jennifer. Her question is, so if it is a private job, contract with owner direct, I must have a notice of commencement to secure lien rights? And that is for Jennifer.
Okay, on a private job, contractor, owner, contract with your owner direct, no, you do not have to have a copy of the notice of commencement. They're supposed to provide that notice. They're supposed to file that, and you should be able to obtain it. And that will help you determine whether you have, who you're supposed to provide notices to. But if you're direct with an owner, and it's not one of those situations where you're direct on a residential 4 buildings or less, you don't have to do a preliminary notice But again, just because they don't have a notice of commencement, that just is a matter of who you're supposed to provide notices to, and the statute specifically provides, no matter who you are, that if you need to do any notices under the pursuant to people that are entities that would be included in a notice of commencement, you can rely on the building permit to send those notices to the people included in that building permit. So if you don't have one, they don't provide one, you don't find one, you should still probably pull a building permit even if your contract is direct. You may not have to do a preliminary notice, but you're going to have to do some proper service, and it's good to know who's who.
Okay. Jennifer also wants to know, what if there's no notice or permit?
That's a good question. I don't know, because the statutes only provide for, you don't lose your lien rights. I mean, if that's the question, the first part as well, if there's no notice of commencement and no building permit that you can find, you don't lose your lien rights. You just need to make sure that you're verifying and trying to do the best you can to verify who the owner is of the project, of the real estate, so that you are, if you're direct, you don't have to do a preliminary notice except for that exclusion. So it's just a matter of making sure that you file the lien properly and serve the right part, the owner, before your 90 days is up. You don't lose it just because you can't find a notice of commencement or a building permit. It's the bigger problem would be if you didn't find it and there was one and you served the wrong people, the wrong entities.
All right. She thanks you for that. There is a question, will you have any other state lien law reviews? Yes, we will, and we will make an announcement at the end of this webinar pertaining to our next one. The next question comes from Wendy. I was told by our NTO company that if they attempt to serve an NTO to the listed owner's rep, but the NTO is never picked up from the post office, the NTO is still considered served. Is this correct?
Mm-hmm. In Florida, as it says, a mailbox rule will apply. So there is, I believe, in the statutes themselves, even specifically, if you do that again prior to the 40 days, you should be good. You put it in the mail, you've got proof, you put it in the mail, certified mail, and it never got picked up, you're going to be okay. Your notice should be fine. And again, that's Florida, and it could differ from state to state. And I would also say, though, if you're looking at, you got to look at the size of your job and how important it is that you don't want to give them anything to argue about or give them any potential defenses. Even a potential defense will just end up costing money to fight about. So if you're talking about a really significant project, a lot of dollars involved, you may want to just cover your bases by doing other methods. You don't have to just send one. But they're fine if they did it that way. But if you want to double protect and make sure, you can hire a courier to do personal service. You can use a FedEx or DHL or somebody to do some sort of verified delivery. But the statutes say certified mail, and they provide for the mailbox rule, saying that if you mail it pre-40 days, you should be okay.
Okay, I appreciate that. And again, there is an interest in other lien law webinars in different states. And again, as promised, we will be making announcements as far as the states that you're interested in. We do encourage everybody who's in attendance, please, if you have questions, take advantage of this opportunity to ask. We still have a few minutes left to address any questions regarding the lien laws. I think what was interesting about that last question, you did mention that there were other options individuals had as far as getting mailings out to an individual. But what if, what was stated, what if the customer refuses, or the owner of the home refuses to accept the mail? Is the lien right still protected by the contractor?
Can you repeat that again?
There could be a case, and just say hypothetically, an individual sends out a notice. They send a notice to the right channels, let's say certified mail, FedEx, courier, etc. However, there's a suspicion by the homeowner or even the GC that's involved, and they decide they don't want to accept it for whatever reason. They refuse to accept the mail. Does that particular individual still have their lien rights?
Yes, yeah, that's the similar situation, and you know, you have to have proof of it, all of those whatever other attempts you've made, and again, do it timely. You can't get out of it by just refusing to read it, or look at it. You've
Okay.
done what the statutes require to provide the notice. Yeah, so
Mm,
you should be good. Again, it's just a matter of looking. It's always you should be. That doesn't mean they won't argue it. Just means if push comes to shove, you probably would win, that argument.
exactly.
And that's why I say we do cover sometimes when we just go, you know what, I'm not messing around with this. I'm going to send it certified mail, FedEx, and I'm going to send a courier out because it's $380,000 and or whatever.
Next question. When we file the notice to owner, if it is a job with surety, the NTO serves as a notice for property regardless if it would be lien or bond. In other words, on the same document, correct?
You could, I think. I mean, it doesn't. If you're talking about if it's a job with a surety, again, I just had to clarify that you're talking about a private job that happens to have a surety as well. So the NTO, or the notice to owner is actually going to be served either way, because in a private job you have to do it. Depending on where you are in the contract chain, and for a private bond or a payment bond on a private job, you have to do it. So I don't see why not. Why it just has to have the notice. What you have to be careful about doing is just making sure that you're following the statute as far as format and language. So it's virtually identical. So I don't know why it would be a problem to have the same thing. You're going to end up serving it on multiples, though. So on a payment, on a bond, I'd say you're going to serve that also on the surety. And you're not going to do that to protect a lien, right? There is no bond, So
Okay.
I think
No,
you're okay.
another question we have, is there any kind of notice between an NTO and filing a claim to lien to let the owner / GC to know that you haven't been paid? We are normally a subcontractor, and sometimes pay apps go for a long time before being paid.
Mhm. It's like a best practices a best practices question, sort of. It's like in some states there are notices of intent to file liens required by statute. So, for example, Wisconsin has one that requires a notice of intent to file a lien be served at least 30 days prior to filing a lien, and that's after preliminary notices, but before you've actually filed the claim or filed your lien with the courthouse. But there is. Otherwise, it's just a best practice kind of thing. I think it makes sense. You've done your preliminary notice. Your lien deadline is 90 days. I think it makes sense to essentially at 60 days be doing that kind of a notice. But basically, it's just a letter saying we still have not been paid. We have lien rights and we will pursue them. It's sort of like a notice of intent to file a lien, but it's not required in Florida. Tracking that's important. The question about payments going way out, you got to watch the 90 days. It doesn't matter. If the deadline passes, the deadline passes. There's nothing you can do to extend it. So I just say internally, you set your deadlines of, okay, I'm going to get the preliminary notice done right away. You do that. You track that, and I'm going to make sure that at 60 days I'm doing a notice of intent like letter that says I have not yet been paid X amount of dollars or whatever, however you want to do that. There's no requirement that it's done a certain way, and then give them 15 days to address it. Otherwise, you're going to have to look to getting your lien recorded.
Okay, I appreciate it. I think that some people do consider how some states do require by law a notice of intent to leave prior to that.
Yep.
I guess in some cases it's just a matter of individual may or may not want to do what's considered some form of a collection notice or a collection letter, or just a letter of intent to collect, a dunning letter, as it were. But as you state, in the state of
Well,
Florida,
and it can upset people, so it could upset your general, and that's really important. All these things are great, and your liens you want to protect, but you're going to get pushback from sales and other people. And I mean, if you're dealing with the general contractor you've been trying to get in with for a long time because they do big jobs, And you know what? They tell you, look, I don't care. We pay you when we pay you. You better not file a lien or you won't get any more jobs. That may be real, and that you may determine that as a business that you're going to let it go. You're going to, because you want the business. It's just important to understand your lien rights so that you can make an informed decision as to whether you want to file the lien or not. I know when you deal with huge GCs, they're going to dictate, and it ends up you're stuck doing what they demand. Sign these incredible, massive waivers. Otherwise, they're not going to pay you. And by the way, we're not going to pay you for 120 days anyway. So, but it's a stadium job, and everybody wants it, or something like that. You know.
Exactly. Well, again, definitely want to thank everybody for taking time out of their busy schedules to attend our current webinar. We definitely want to thank our presenter, Jeff Nicolette. Jeff, we do appreciate you taking out time from your busy schedule as well with Wagner, Falconer, and Judd. And you did an excellent job. A lot of people truly appreciate the information that you brought forth. For any questions not addressed during this webinar, all are welcome to submit your questions directly to Wagner, Falconer, and Judd, Ltd. The email address that is provided below. Have your pens ready. It is liengroup@wfjlawfirm.com. Again, any questions not addressed, you are welcome to submit your questions directly to Wagner, Falconer, and Judd. And again, that email address is liengroup@wfjlawfirm.com. Also, we would like to announce that our next free webinar series will address lien laws. That's right, for the state of Texas, which is scheduled to take place in August of 2019. The state of Texas brings steak, cowboy hats, boots, steers. No, I'm just joking. I'm sorry. That was bad. But anyway, we are excited about presenting that. I know a lot of our customers and people are interested in the lien laws regarding the state of Florida. Regarding the state of Texas. We do look forward to that taking place. We will be making announcements as far as the exact date. In the month of July, what we will do is provide a replay of this current webinar with the state of Florida, and you will be able to address that by way of a link to Wagner, Falconer, and Judd, or to Nationwide Notice platform. We will make that announcement and provide that information to you. With regards to the invitation to the Texas webinar in August, invitations will be sent to all in attendance as well as all contemporaries. If you know someone who would be interested in attending our next free webinar, please have them contact Nationwide Notice at the email provided below, which is seminars@nationwidenotice.com. Again, that's seminars@nationwidenotice.com. And again, I have to announce that this webinar for today will be replayed by way of Wagner, Falconer, and Judd and Nationwide Notice online platform. Emails will be sent out to everyone in attendance and contemporaries in how to make that connection to view the webinar. Again, we want to thank all for joining us. We want to thank our hosts and all in attendance, and we look forward to seeing you next time. Take care, be well, have a great day.
Thank you all.